If it pleases the court, my name is Pradella, initial J, and I appear on the behalf of the plaintiff, So Snooty Incorporated. Your Honour, the objective of the law is to provide stability. Manipulating its true intended application by skewed interpretations is in itself contradictory to stability. While the defendant will argue that my client has engaged in deceptive conduct, I remind Your Honour that the law is not a flexible catch-all safety net for those who have been careless in commercial activities and wish to revoke their contractual obligations. Implying that the law is elastic encourages the community to disregard the seriousness of trade agreements and contracts in general. As such, covenants must be enforced to avoid detriment to the ability to rely on the performance of promises. With this in mind, counsel for the plaintiff will exhibit two submissions. Firstly, that Snooty did not engage in deceptive or misleading conduct pursuant Section 18 of the Australian Consumer Law Act of 2011 by failing to inform the defendant of the height of Lot 2. And secondly, that the plaintiff should not be stopped from denying reimbursement of fit-out costs. I will now proceed to investigate the first submission. The defendant, who I refer to as Papa, claims that my client Snooty has engaged in deceptive or misleading conduct in trade. The real cause of the defendant's mistake was carelessness. Snooty's estimation made via email on the 3rd of June was made subject to levelling, which had not yet occurred as expressly advised. Papa's mistake was relying on Snooty's silence in recklessly assuming that the estimation had not changed after the lot levelling occurred. The 2010 High Court case of Miller and Associates Insurance Broking Proprietary Limited and BMW Australia Finance Limited provided clarity for such instances when Justices French and Kiefel agreed that the law does not oblige contracting parties to volunteer information for the protection of careless parties unless a reasonable expectation suggests otherwise. Contrary to the classic 1988 case of Hendry Investments Proprietary Limited and Collins Marrickville Proprietary Limited, the plaintiff at no instant assumed or owed the responsibility for ensuring that the defendant did not purchase materials which would remove the Lot 2 hangar's legal and contractual compliance. The recent 2018 case of Baum and Barport also confirmed that a duty of disclosure will not exist in this instance, as only those who are subject to a contract for the purchase of materials should be responsible for ensuring that they are fabricated to the correct size. Your Honour, it is clear that the defendant has not fallen an ill-fated victim to deception. Rather, he did not afford the level of care owed to an agreement of such an importance. Such a circumstance was well summarised in the 1978 case by Justice Foster in Morningstar Cooperative Society and Express Newspapers Limited, where he held that the law protects everyone but a moron in a hurry. The second submission which the defence will now present is that Snooty will not be stopped from denying the payment of the defendant's fit-out costs. This is due to both the ambiguous nature of the plaintiff's representation and the defendant's lack of reliance. In the 2014 High Court case of Crown Melbourne and Cosmopolitan Hotel of Victoria Proprietary Limited and Agnon, it was established that the representation in question must be precise and unambiguous in order for estoppel to be imposed. It was held that where detriment is suffered as a result of reliance on a representation, as has occurred in the dispute before Your Honour, equitable estoppel will only interfere where the representor failed to respond to indicators of the representee's reliance, pursuant paragraph 38. The defendant here, however, represented not a single steadfast sign of his reliance on Snooty's representation, which could be corrected. Certainly, he did not place the detrimental reliance on the representation which is required for equity to intervene, as found by the 2014 case of Sidhu and Van Dyke at paragraph 58. While the defence may argue that his quote from the 4th of July was an indication of some reliance, this itself builds upon the ambiguity of the representation, as the quote was only for the cost of architect fees, equipment and decor, not the fit-out costs, as represented by the plaintiff. Surely, Your Honour, the lack of certainty surrounding a crucial agreement removes the justification in enforcing it. Counsel for the plaintiff has presented two submissions to the court. Firstly, that my client is not liable for misleading or deceptive conduct by failing to inform the defendant of the height of Lot 2. And finally, that the plaintiff will not be stopped from denying payment of the defendant's fit-out costs. Your Honour, the law is a provider of communal stability, not a safety net for those who are careless in arrangements which are due great care. Applying the law in a way which suggests otherwise, in fact, creates instability, for obligations become traversable, and those who do afford due care will pay the price.